Good afternoon, everybody, and thank you for joining us for another webinar event in the ConMaciel-Carey 2023 OSHA webinar series. This is a really exciting topic to cover today. Exciting, but awful. One of these things where we're being accused of being the boy who cried wolf lately, but I'm telling you, we're just living in a village overrun with wolves, and we're getting into today two of the really significant new enforcement developments, and as OSHA describes it, new tools in the toolkit that OSHA has rolled out as the agency has moved beyond COVID-19 to focus on some of these priorities and some of these plans and enforcement strategies that I think it must have been chomping at the bit to roll out under the Biden administration, but felt constrained to focus all attention and all hands on COVID-19. Now we're seeing the agency sort of shift its focus to where I think it's where it wanted its priority to be, and that is ratcheting up enforcement in a bunch of creative ways. And that's what we're going to be talking about today, is two of those ways that OSHA has changed the enforcement landscape to really make employers feel the pain in a new way. And those two things are changes to the Severe Violator Enforcement Program and changes to what has historically been referred to, or colloquially referred to, as OSHA's Egregious enforcement policy, which they now refer to as the instance-by-instance citation policy. So that's what we're going to be getting into today. And this is, one of these I think probably saw on the agenda and the program description, sort of a discussion about willful and repeat violations and some of the consequences of that. Some of the consequences of willful and repeat violations has been historically getting tripped up into the Severe Violator Enforcement Program, or possibly facing these per instance citation issues. And we put that on the agenda because we had a sense that these changes were coming. We had heard from some of our contacts at OSHA that there was some kind of change coming to the egregious enforcement policy. And so now that we've seen what those changes are, rather than do a broad overview of willful and repeat violations, we're instead doing a focus on these two particular changes: the Severe Violator Enforcement Program, per instance citation policy, anti-grouping, and what the consequences of those programs are. And just real quickly to introduce ourselves, I think everybody hopefully on the call already knows me. I've been doing this for 9 years of this webinar series, practicing OSHA law for 22 years. I'm Eric Kahn. I'm one of the founding partners of ConMaciel-Carey, and I chair the firm's national OSHA practice group. I won't belabor my introduction, but I'm very excited to introduce for the first time to the OSHA community here, one of our new associates, Darius Rahani-Shukla. Darius joined us, it's probably close to a year now, and he's done some webinar programs with the firm. So if you join on our labor and employment webinar series as well, you've maybe seen Darius present before, but today I think is the first one he's doing as part of our OSHA webinar series. So I'll let Darius introduce himself a little bit, and then we'll jump into the program.
Hi, everyone. As Eric mentioned, my name is Darius Rahani-Shukla. I'm an associate here. So I work on both the OSHA side and the employment side, and today what I'll be talking to you about is the instance-by-instance violation policy, which I'm sure you'll all be very interested to hear about.
Excellent. All right, well, let's jump right in. So the Severe Violator Enforcement Program, those of you that know me well, have seen me speak or have seen me speak at conferences or on this webinar series, know that I have a really unhealthy obsession with this program. I have for years been a critic of the way the Severe Violator Enforcement Program has been implemented by OSHA, and I've got bad news for you. This program that I thought was broken to begin with has just gotten worse. And we'll give you a little bit of the backdrop on what the Severe Violator Enforcement Program is, and then we'll get into the big changes that OSHA just announced a few months ago. Prior to the Severe Violator Enforcement Program, the precursor to this program was something called the Enhanced Enforcement Program. And it was a very similar concept. It was introduced back during the George W. Bush administration. And the idea was it would allow OSHA to target its enforcement resources at bad actors, at employers that OSHA believed required additional enforcement attention. The program itself was found by the Department of Labor itself to be broken in a lot of ways. Some of the biggest issues with it was that it focused on the wrong employers. It focused on too many employers were swept into the program, which watered down the agency's ability to apply those additional enforcement resources to those who had been designated as bad actors. And as a result, the agency wasn't able to conduct follow-up inspections or sister facility inspections, or to really, implement the purpose of the program, which is not just to identify bad actors, but to apply more attention and more enforcement resources to them. That program was retired in 2008, and it was replaced in 2010 during the Obama administration with a program that is now, the one that we have now, is called the Severe Violator Enforcement Program. From 2010 until a few months ago, what the Severe Violator Enforcement Program did was directed enforcement resources at employers that OSHA believed were demonstrating indifference to their OSHA Act obligations. So same concept as the EEP, the SVEP was about identifying, using data and using experience to identify employers that needed more enforcement attention, and then applying that attention, conducting more inspections, holding those employers accountable in a variety of different ways. From 2010 to up front, right, I say I'm a critic of the program. The goal of the program is laudable, right? I think any enforcement agency that is using data in a smart way, using experience in a smart way to target its limited enforcement resources is a good thing. My problem with the Severe Violator Enforcement Program, there's a bunch of problems that I have with it, but one has been that it's not targeting the right employers. I think it's doing a poor job. The selection criteria or qualification criteria, I think, does a poor job of identifying indifferent employers, identifying bad actors. And the things that I thought were bad about the way that was happening have gotten worse. The other big problem I have with it is timing, and I'll talk about that later, when you qualify in, on what basis you qualify in, and how you get out. Those criteria have not been fixed, and in some instances have gotten worse also. So it's like the agency is watching our webinars and trying to find out how they can make me more upset. And that's what they've done here in September 2022. But up to that point, just to give you the history, an employer would qualify into the Severe Violator Enforcement Program by being accused of committing violations that fall into one of these four categories you see in front of you. Any egregious enforcement action, and that's an important concept because the thing that Darius is going to talk about after I'm done with my rant about the Severe Violator Enforcement Program is a change to the Egregious Enforcement Program. But I will clarify that change, maybe I'll weigh in after Darius describes what's happening to the instance by instance program. But the way that OSHA has used its egregious enforcement policy has not changed in the context of severe violator enforcement, the Severe Violator Enforcement Program. And that means an egregious enforcement policy, an egregious enforcement action is one that is historically been considered willful plus some aggravating circumstance. And so it is those circumstances where OSHA thinks something is really outrageous conduct, and they will cite it not just with a willful violation, but for multiple willful violations of the same standard. So you fail to, enforce your hard hat policy, OSHA would cite you for not just one willful violation, but for a willful violation for each employee not wearing their hard hat. Any circumstance like that would qualify you into the Severe Violator Enforcement Program. The next category is one or more willful, repeat, or failure to abate violation related to a fatality or a catastrophe. So if you had a willful violation for not enforcing your fall protection policy, not requiring employees to wear a harness and lanyard, an employee falls and dies as a result of that, that one willful violation and that death qualify the employer into the Severe Violator Enforcement Program under the old qualifying criteria. Down at the far end of this slide, 3 or more willful, repeat, or failure to abate violations related to the process safety management standard. This is a special standard for the oil and gas industry and chemical manufacturers. And this is about keeping chemicals in the pipes. If you violate that specific standard, 3 or more willful or repeat violations in a single enforcement action, that would qualify you into the Severe Violator Enforcement Program. You can see special here in our firm color orange. We've highlighted a special category, and it's not just special because it's the one that changed, and it is, and that's what I'll talk about in a second. It's special because it was really the one that was catching most employers, that was qualifying most employers into the program under the old criteria. And that was 2 or more willful, repeat, or failure to abate violations in a single enforcement action related to a high emphasis hazard. And the high emphasis hazards, they're listed here at the bottom of the slide. It's these specific industries, these specific standards, or these specific hazards. And it was only 2 or more willful, repeat, or failure to abate violations of those particular categories that would qualify you in this criteria, the high emphasis hazard criterion, that would qualify you into the program. And we've highlighted that in orange because that's how most employers have been qualifying into the SVEP program. Almost 70% of the employers that qualified in over the first 12 years of the program qualified in because of 2 or more willful, repeat, or failure to abate violations related to one of those high emphasis hazards. And beyond that, and I keep talking about willful, repeat, or failure to abate, that's really not what this program is. This program is the repeat violator program. And that's one of my big issues with this, is I think this is a program that is designed for willful violators, but as it's being implemented, it's focusing on employers who are accused of repeat violations. And repeat violations can be a sign of indifference. I get the concept that OSHA is rolling out here, but in reality, employers with a significant number of workplaces over 5 years getting cited for violations of the same standard over a 5-year period across maybe dozens or hundreds of workplaces is frankly not a good indicator of an indifferent employer. Willfulness requires some actual intent. It involves some knowledge of the violative condition or some conduct that is so outrageous that it's willful regardless if you knew what the standard required. That, to me, is what the Severe Violator Enforcement Program should be about. That, to me, is what an indifferent or bad actor employer is, those that are confirmed to have intentionally violated a rule or have been so callous that it wouldn't have mattered if they knew what the rule is. A repeat violation involves no aggravated intent or awareness at all. Conceptually, OSHA says if you were cited once in the past and you're cited again in the future, then it does involve some heightened awareness. But the reality for medium and larger employers with many workplaces over a 5-year period, there may be really no heightened awareness at all. You've got an entirely different group of people in an entirely different part of the country getting cited for the same standard 5 years apart is not anywhere close to the same kind of indifference as willfulness. But yet you can see in the bottom of the slide that over 75% of employers who are qualifying into SVEP in any of these categories are getting in because of repeat violations, not willful violations. The egregious category is the only one that is exclusive to willful violations. All the others, it could be willful, repeat, or failure to abate, and it is predominantly repeat violations that are qualifying you in. So you can see that about 70% were getting in because of this high emphasis hazard category. I already thought that was too many, and too many of the wrong employers because of this repeat element. Well, a change came along, announced in September of last year, and it's being implemented for inspections that begin after that November 15th, 2022 date, or at least for citations that are issued after that date. I think it's the latter. I think If a citation is issued after September 15th, it's subject to this new qualifying criteria. And here's the new criteria. Well, first, we'll start with what hasn't changed. What hasn't changed is the fatality catastrophe criteria, one or more willful or repeat related to a death or the hospitalization of 3 or more employees still will qualify you into the program. The egregious criterion hasn't changed. Still, any per instance willful citation will qualify you into this program. And that's the important distinction I was trying to qualify before. It's still per instance willfuls only. What Darius is going to talk about is some new authority that OSHA has granted itself to cite per instance for things other than willful violations. But for SVEP purposes, it's still per instance willful violations only. OSHA eliminated the PSM criterion, that there be 3 or more willful or repeat PSM citations would qualify you in, but it's not, this is not actual relief for the process safety industries. What they actually did was lower the threshold, because now it doesn't matter whether it's a PSM citation. The big change here, and it doesn't matter if it's one of these 9 high emphasis hazards at the bottom of this slide, OSHA has eliminated the high emphasis hazard limitation to qualifying into the SVEP program. Now, any 2 or more high gravity, willful or repeat or failure to abate violations from the same inspection involving any hazard, any standard, any industry, that will qualify you in. So it doesn't take 3 PSM violations. Now 2 PSM violations will get you in. And it doesn't take just 2 or more willful or repeat violations of falls, amputations, combustible dust, lead, whatever. It's any standard. So it used to be that, daisy chaining your, temporary flexible cords, or using, a power strip with an extension cord into the power strip. You could have, 3 or 4 or 5 willful violations or repeat violations of that issue, and it would not qualify you into SVEP because it wasn't a high emphasis hazard. You could have multiple repeat violations of blocked exit routes, and that would not qualify you into the Severe Violator Enforcement Program because it wasn't a high emphasis hazard. That limitation is gone. Now, any 2 or more willful or repeats of any standard, any hazard will qualify you into SVEP if it's high gravity. And we'll talk a little bit about what that means, what the gravity of a citation is in just a moment. OSHA announced in a presentation they gave about this program that if this criterion existed last year, in fiscal year 2022, which by the way was a year when inspection numbers were still a little bit depressed from COVID-19 issues, and a lot of inspections that OSHA was doing were COVID-19 related inspections, which would not have been very conducive to severe violator outcomes, by its nature. And even under that, even under the data from that year, if this criteria had been in effect, there would have been more than 100 more SVEP cases, basically 3 times as many employers qualifying into the Severe Violator Enforcement Program. I'm expecting that this was going to be 4 and 5 times more employers qualifying into the program as we continue to move out of the COVID-19 era at OSHA and into this era where OSHA is much more aggressive on the enforcement side. They've hired, 1 in 5 compliance officers is brand new. They've added something like 150 new compliance officers over the last 2 years. They're conducting more and more inspections. They're looking for more and more repeat violations and ratcheting things up. So we're going to see SVEP really balloon as a program, and something that hopefully had been off of most employers' radar is now a huge landmine for them, because it can be any standard in any industry with a continued extreme focus, I think, on repeat violations. So that's the big change there on the SVEP front. Here's Assistant Secretary of Labor for OSHA, Doug Parker. talking about the update to the Severe Violator Program and saying that this is expanded criteria. That's what it is. There's no other way to look at this other than expanding the eligibility or qualifying criteria to get in, and that this expansion reflects the Biden-Harris administration's commitment to ensuring OSHA has the tools it needs to ensure employers protect their workers and to hold them accountable. And so you hear OSHA all the time. This is their mantra during the Biden administration, is using all the tools in the enforcement toolkit. And this is one of those tools, expanding the way that they can brand employers as bad actors. So this high gravity concept is a really interesting one, and it's one that Darius is going to talk about also because it's relevant to the big changes that were announced to the instance by instance citation policy as well. But it's a criteria now for qualifying into the Severe Violator Enforcement Program. This two or more high gravity willful or repeat violations of any standard will qualify you in. Gravity was a thing that by and large we ignored. That in my 22 years of practicing in this field, I basically didn't pay attention to the gravity designation of a citation. I can't remember ever paying attention to the gravity designation that OSHA applied to a citation. I knew in the background it was there. I knew that OSHA was using it as part of its penalty calculation formula, but it wasn't a thing like the characterization, right? We all pay attention to, is it willful? Is it repeat? Is it serious? Is it other than serious? But gravity just didn't really matter. Well, now it matters. Now it's something that might factor into qualifying you into the Severe Violator Enforcement Program, or strategically getting you out of the Severe Violator Enforcement Program. It's become a thing that you can perhaps negotiate, not perhaps, you can negotiate about gravity. And as a way perhaps to get a qualifying citation to no longer be a qualifying citation, and so that you would be removed from the Severe Violator Enforcement Program. And one of the things we're going to talk about, strategies for how to avoid the program or to get out of the program at the end. OSHA is always very, very clear, and they'll tell you this if you go into an informal settlement conference or a mandatory settlement proceeding where SVEP is on the table, where you've been qualified into the program and you're negotiating about those citations. OSHA is going to say, we do not negotiate about Severe Violator Enforcement Program status. It is not going to be a settlement term that you are released from the program. However, if the qualifying citations are changed in a way that makes them no longer qualifying citations, then you will get out of the program. And you can negotiate about those characteristics of the citations. So when OSHA says we're not going to negotiate about SVEP, they will perhaps, and I have done this already, negotiate about the gravity of a citation. They will negotiate about the characterization of a citation. They will negotiate about whether a citation is linked to an incident in the violation description as a way to perhaps get out of the program. We'll talk about those strategies at the end of my discussion. But that's an important element here now, is gravity. So what in the world is gravity? Something we haven't paid attention to before. And what does it mean to be high gravity? The gravity of a violation is made up of the violation's severity and probability. And to be high gravity, the violation has to be both high severity and greater probability. So high severity means, or the severity itself means, the worst case outcome as a result of the violative condition. And for it to be high severity, it needs to be that worst case outcome is death, permanent disability, or irreversible illness. So high severity is the worst case outcome, is the worst case outcome, death or serious permanent injury or illness. Probability is the likelihood that injury or illness will occur as the result of the violative condition. And to be greater probability, that means that the likelihood that injury or illness will occur is judged by OSHA to be relatively high. So we've got this little table here, but the big takeaway is high gravity equals high severity. Worst case outcome is death or serious permanent injury or illness, and greater probability. that there is a high likelihood that injury or illness will occur as a result of the condition. All of that needs to occur in conjunction with willfulness or repeat of any standard to get you into the Severe Violator Enforcement Program. Here's a little bit more detail about this gravity concept that was not something we cared about or thought about in the past. What's new and different on this slide compared to what was on the other slide is down here under probability. I think this is interesting to evaluate the factors that OSHA considers when determining the probability that injury or illness will occur in determining whether it's greater probability or lesser probability. They will look at the number of employees exposed. So if there's only 1 or 2 employees that work with that machine or work in that workplace or potentially exposed to that hazard, that pushes things down in terms of the probability of a bad outcome occurring. The frequency or duration of the exposure to the hazardous condition obviously factors into the probability. The proximity to the hazardous condition, how close do employees have to work to this condition or this equipment or this hazard, whatever it is. Whether there is appropriate PPE that has been assigned and that is ordinarily or always or was in this instance being worn would factor into OSHA's probability analysis. Training, how effective is your training program to recognize and avoid the hazardous condition or to effectively implement the engineering and administrative controls at the workplace. The greater the quality of the training or the frequency of the training or that the training occurs at all will impact OSHA's evaluation of the probability designation here. And then the age of employees. I think OSHA is basically saying if you have young youth employees, we're going to increase the likelihood of probability because of youth, inexperience, and perhaps immaturity factoring into that. This is how OSHA is going to come up with their determination about gravity. But these can also be tools that you use again in that negotiation process when you're trying to convince OSHA to change the gravity finding so that you might get out of SVEP through some settlement. Use these factors, point to these factors. Look, we had PPE assigned and used. We've got a good training program. Very few employees are involved in this operation. And when this operation occurs, it occurs for a short period of time. We think you got you designated as greater probability, but based on all of those factors, it should have been lesser. And so you're going to start negotiating about these factors that were something that we really never paid attention to in the past. So pretty interesting stuff there. So what does it mean? What are the consequences of qualifying into this program? We've got really 2 slides on this. The first, this should say direct consequences. It used to say intended consequences, but I think OSHA intended both the direct and indirect consequences when they crafted this program. But the direct consequences are a mandatory follow-up inspection at the cited facility and mandatory sister facility inspections nationwide, including in state plan states, of sister facilities of the original workplace that qualified the employer into SVEP. OSHA is going to get out there and visit sister facilities. This is when I say now, under the original program for the last 12 years, there was a cap on those sister facility inspections. OSHA would only do up to 10 for very large employers. Now that is unlimited. OSHA can get into as many sister facilities as it wants under the Severe Violator Enforcement Program. Other direct consequences written right into OSHA's directive for the Severe Violator Enforcement Program is settlements of these cases, settlements of severe violator cases. OSHA is going to require some enhanced settlement terms. And they basically say, look, you don't have to accept any settlement proposal we ever make. You don't ever have to settle a case with us. You can go to hearing. But if you're going to settle a severe violator enforcement case, we're going to expect to see some enhanced settlement terms. Usually that means some third-party involvement, a third-party consultant to do an audit at your workplace or multiple of your workplaces, a third party to review certain written programs, review your written lockout, tagout procedures or your fall protection program, and to provide advice and recommendations to enhance that program. Third parties are a big favorite of OSHA's in SVEP settlements. Corporate-wide abatement, SVEP cases, technically abatement is limited to the workplace that is inspected, but in SVEP cases, OSHA is going to generally write into the settlement agreement an expectation that whatever changes are made are implemented throughout the organization. That's generally my recommendation anyway, because I'm very, very focused on helping employers avoid repeat violations, because repeat violations can dump you into this dreaded severe violator program. They carry 10 times higher penalties. They can affect your ability to bid on contracts. They can affect your ability to retain employees or to recruit employees. Negative press releases very often accompany repeat violations. Lots of reasons to avoid repeat violations. So generally, when we are implementing abatement or implementing enhancements, I'm encouraging my clients to implement those on a company-wide basis, whether it's written into a settlement agreement or not. But in an SVEP settlement, it's going to be an express term of the settlement 9 times out of 10, which means it's an enforceable term of a settlement. It may not just be, if OSHA came out and saw the same issue at another facility, it might be a repeat violation without this SVEP settlement. With the SVEP settlement, it might be a failure to abate with daily penalties, and they're much more likely to find it. And some of these things are not regulatorily required, right? We're talking about enhancements that are implemented corporate-wide. OSHA couldn't cite you for not implementing an enhancement at another facility unless it was part of a settlement. So that's why they ratchet things up and they put these enhanced terms in their SVEP settlements. The last thing that is a direct consequence of qualifying into SVEP is public shaming. And you've heard me talk about this program before, OSHA's public shaming program. Usually it comes in the form of a nasty press release, and severe violator cases, if it's not 100%, it's 99% of all severe violator cases have involved some really ugly press release that OSHA issues the day the citations are issued, calling out the employer, ugly inflammatory quotations from some senior OSHA official about the employer, and calling out the employer as a severe violator, usually in the headline of the press release. So all very bad press there. But in addition to just bad press releases, and you can get bad press releases without qualifying into the Severe Violator Enforcement Program, but in addition to the bad press releases, there is also literally a bad actors list on OSHA's website, the Severe Violator Enforcement Program log. I guess maybe, I don't know if that's literal, maybe it's figurative then. It's a literal Severe Violator Enforcement Program log and a figurative bad actors list posted on OSHA's public website. And this is a little snippet from it. It identifies the employer, the city where they operate, the inspection number, the details that, why the employer qualified into the program because of those citations, and all kinds of details about the citations. This log on OSHA's list, it's a spreadsheet that is searchable, sortable, downloadable, exportable. It is user-friendly for all those users who might intend to do you some harm. And that's where we get to what we call the indirect consequences of qualifying into the Severe Violator Enforcement Program. We talked about bad press releases and the bad press associated with getting put on this public log. That harms a company's reputation. If you are in the service industry, if you bid on contracts, if you are in hospitality or retail, really any company who depends on its reputation, which is almost every company, private company out there, being designated as a bad actor by OSHA is bad news, especially today as we have moved into the ESG era where governance and environmental and sustainability and good governance, which generally includes safety, has become such a hot button issue, right? Public companies are reporting this in their public reports, and contract partners and business partners are asking you to share on your ESG and safety and environmental performance, being designated as a severe violator is a huge blow to business prospects and companies' reputation, especially in this ESG era. Harm to employee retention and recruiting, being designated as a bad actor by OSHA is not helpful to recruiting. And I've seen this in a very direct way. OSHA puts out an ugly press release, designates somebody as a severe violator, and potential future employees during interviews, during recruiting discussions, raise this, say, we just read this press release. Can you explain this? I'm concerned about coming to work here in light of this. It's very visible, it's very public, and we have seen this, especially over the last several years, as employers are competing to maintain staffing, competing for employees in a way that we haven't seen historically. Having something out there that calls you a bad actor by a federal regulator is not going to help you compete on the recruiting front for employees. We have seen insurance companies reference a severe violator designation in their dealings with employers, either as an excuse to increase their rate modifier, as a way to increase their rates, as a way to even consider and threaten to drop an employer from coverage, or to sort of use it as additional leverage to get changes from some of these loss control audits that they might do. They'll hold that severe violator thing over your head and the risk of losing coverage to push changes in the workplace as a result of that. So you can see it affect your insurance relationship. We have absolutely seen it in almost every case that I've worked on where there was a severe violator designation and a union at the workplace. The unions have seized on this and used this during at the bargaining table. And we've even seen some unions use the SVEP designation to target employers for an organizing campaign, or used it in the organizing campaign to influence employees thinking about, hey, you need us here. Your employer doesn't care about you. Your employer is a bad actor, and we can help with that. So it can definitely affect your labor relations and the union organizing prospect as well. And then there's all these other parties out there who don't have your best interest in mind, and who can use something like a severe violator designation to hurt you. Plaintiffs' attorneys, the media, your competitors, you name it. If there's somebody out there who's trying to undermine your company, undermine your business, having something like a severe violator designation by a federal regulatory body is the sort of thing that they're going to seize on and use against you. I'm going to check some questions here. Yeah, so there's a good question here about third-party audits, that this is a pretty common feature in consent decrees with EPA as well. And in that context, EPA has some approval authority over who the third party is. And the question here is, in the SVEP context, is OSHA going to use that kind of model where they have some kind of approval authority over who you hire and how you define that engagement? And the answer is basically yes. I mean, it is not mandatory, right? And you're going to get the chance to negotiate. But in almost every instance, OSHA's opening gambit in their proposal for a third-party auditor involves some process whereby you present to OSHA the auditor that you've selected, and that OSHA has some window of time, 30 days, 2 weeks, whatever, to raise an objection to the auditor. I can tell you I've not seen OSHA exercise that authority in any situation that I've worked on. I mean, we make good choices about third parties, good, sophisticated, credible, reputable consultants. And we've got a good stable of those that we partner with that we can help you identify. But usually OSHA does ask for that in these settlements. I've seen some where we've negotiated that out, others where we weren't concerned. Usually what we do is we talk to OSHA about who we intend to use before we sign the agreement, so we know that they're going to approve. But that generally is a term that they're negotiating into these settlements. So it's an interesting situation. The last thing that I'm going to talk about with SVEP, which is another thing that has been a huge concern of mine about this program, and frankly, an element of this program that I think makes it literally unconstitutional. And I talk to my friends at OSHA about this all the time. I think what they're doing is not just bad policy, but it's unconstitutional. Employers qualify into the Severe Violator Enforcement Program and immediately begin to feel and experience the consequences of qualifying into the program, with the bad press release, getting put up on the log of severe violators, and being held to a different standard in settlement discussions with the agency. All of those consequences kick in at the time that the citation is issued, not when OSHA has proven that you committed willful or repeat or failure to abate violations related to high gravity violations, or related to a death or multiple hospitalizations or whatever. It's just at the time that OSHA has accused you of committing that kind of violation, when those citations are nothing more than unproven allegations, when you've not had your day in court, when you've not had a thing that our Constitution calls due process. OSHA conducts its inspection. That's a one-sided affair. They make their own determinations about what they're going to cite. And by the way, they've got that strict 6-month statute of limitations, which often means OSHA is rushing and doing an incomplete job and not having a lot of time to dig in and to interact with the employer before issuing citations. And they make allegations that are very often wrong and very often proven wrong, but you are immediately qualified into this program. And your name goes on that log the next time they update it, which I think is on a quarterly basis, generally before you've had an opportunity to even sit down with OSHA at an informal conference, certainly before you've had a chance to sit down at a mandatory settlement proceeding, which most severe violator enforcement programs will be put into that mandatory settlement proceedings process. And before you've had an opportunity to show OSHA that they got it wrong, or prove to an adjudicator that OSHA got it wrong, you immediately are experiencing these consequences. And then there's on the backside, that's when you get in. Now let's talk about how you get out. And I've been calling the Severe Violator Enforcement Program the Hotel California. You can check in, but you can never leave for more than a decade now. When the program was first introduced by OSHA, there literally was no exit criteria at all. It didn't say anything about how anybody was to get out of this program once you qualified in. We were hysterical about that and pushed OSHA, and ultimately they agreed to put some exit criteria into the program. But the exit criteria, as it has existed for the last 12 years and was not improved on with the changes that OSHA just announced in September, is to me a pretty untenable gauntlet. It is almost impossible for employers to get out by the exit criteria that is written into the SVEP program. This is what it calls for: abatement of all of the related violations. Of course, you've got to do that if you've accepted it in a settlement or it's been proven by OSHA and an ALJ affirms it. You've got to abate those violations. That's not the hard part. It might be hard, but it's not the part that I think makes this an unreasonable set of criteria. You have to have paid all the penalties that are set by the settlement or set by the adjudication. Again, that's not a problem. You have to have had at least one follow-up or referral OSHA inspection, one of those sister facility OSHA inspections. That's a little unfair because you can't control that. If OSHA isn't doing the inspection, you don't really want them to, but you can't get out until they do it. You don't have any control over that, but you can't get out until that happens. And then here's the kicker. OSHA thinks of you as a bad actor. They've put you in this program called the Severe Violator Enforcement Program, and over a 3-year probation period, they are going to be conducting follow-up inspections and unlimited sister facility inspections, walking in the door thinking that you're a bad actor, And you can't, in any of those inspections over a 3-year period, get any related serious violations. Not willful and repeat that qualified you in, but serious violations restart that 3-year clock. And serious violations, it's not in this deck, but we talk about this when we talk about OSHA enforcement data. It's something like 80 to 85% of all OSHA citations are characterized as serious or worse. So if they come in the door, they think you're a bad actor, they're coming in the door a lot because of this SVEP program, you got to go 3 years without a serious violation. It's just almost impossible. And the reality is, if you look back over the last 12 years, very, very, very few employers have gotten out using this criteria. I think it was like 9 or 10 years, or maybe 8 or 9 years before a single employer got out following that criteria. And now you're starting to see it happen occasionally, which is good. But it really is almost impossible for employers to get out. So one of the things that changed in September, which is a good thing, is that this 3-year probation period can now be reduced to 2 years if you agree to certain enhanced settlement terms, like the implementation of a safety and health management system. Hopefully, most employers have a good written safety program that looks and feels like what OSHA thinks of as a safety management system. So, most of my clients would be eligible for the 2-year period, which makes this a little bit easier, but still going through that gauntlet with follow-up inspections, sister facility inspections, with OSHA thinking of you as a bad actor without getting a serious is a pretty tough situation. So I'm going to talk real quickly about what I think are the real exit criteria, because that's too hard. And in practice, we're seeing not really available to many employers. The real way to get out is right up front. You've been qualified in with bad citations. You've got to tackle those citations through the settlement process, through the litigation process, to get the qualifying criteria changed. The qualifying citations withdrawn or amended in some way that makes them no longer eligible for the severe violator. So you're dumped into the program, but you can be lined out and removed, within a couple of months, within a few months, if you're able to negotiate changes to those citations or to litigate, and that would be more than a few months, to get to the end of an adjudication process where an ALJ changes the qualifying citations in a way that makes them no longer qualifying. So that might mean getting rid of a willful or repeat characterization, or if you're getting in because of 2 or more willful or repeats, getting it down to a single willful or repeat. We have confirmed OSHA's view that if you have grouped multiple willful or repeats into citation 2, item 1A, 1B, and 1C, if they're grouped like that with a single penalty, then that counts as only one willful or repeat violation. So that might be a way to get out of the program. And now we talked about it already, that negotiating about the gravity, generally that's going to be around probability that you're negotiating. If you can negotiate the probability of a serious injury occurring down to moderate or lesser, I guess it's lesser, then you would get out of the program as well if that was the qualifying criteria. So that's some tips and strategies there. And then the other strategy, and I'm not going to go through this in detail, but the main thing is, and it continues to be, repeat violations are what qualify you in. So avoid repeat violations. And that's easy to say, but it's, it's, to me, it's been a fundamental change in the way I practice and represent employers back about 8 years ago, 10 years ago, when OSHA became extremely focused on finding and citing more repeat violations. You've got to think about repeat violations in every interaction you have with OSHA. And I see so often employers get a set of citations, they're characterized as serious with a relatively small penalty. They go into an informal and OSHA says, hey, we'll change it to other than serious and we'll cut the penalty in half, or we'll make it $0 penalty. And everybody says, wow, that's great. I win. My boss is going to be so excited. Sign me up. I'm going to take those citations. But now you've got citations on your record that can serve as the basis for repeat violations. You just have to be mindful that no matter the characterization, no matter the penalty, if it is a high risk repeat standard, you've got to tackle that. You got to take it seriously, and you've got to negotiate it just like you did back here. The ways that you would get out of SVEP, you've got to treat it the same way, as though it is in this moment already an SVEP citation, and try to negotiate it out of a standard that's likely to be repeated, and a language that is likely to be repeatable, and really tackle it that way. And then if you do end up with citations on your record, make sure you're addressing it on a company-wide basis, and communicate effectively with your sister facilities to try to avoid those repeat violations. So that was my SVEP rant, my semi-annual SVEP rant, and thank you all for joining me for that. I'm going to kick it over to Darius now to talk about OSHA's new instance-by-instance citation policy.
So I want to start with this, but we'll just go over kind of a brief history and background of OSHA's I-by-I policy, and then we'll go into where we are today. OSHA's instance-by-instance, or IBI, as I'll refer to it mostly today, was first memorialized in 1990 in an enforcement directive called Handling of Cases to be Proposed for Violation by Violation Penalties. This policy became to be known as OSHA's Egregious Enforcement Policy because OSHA's policy was to use it only in circumstances involving conduct found by OSHA to be worse than just willful. Stated differently, the standard for such conduct was called Willful Plus. So where violations were willful and they resulted in a fatality or catastrophe, the employer had committed so many violations as to undermine an effective safety program. There's an extensive history of violations and or persistently high injury rates, or that conduct as a whole demonstrated clear bad faith. In those instances, the employer qualified for instance citations, and I'll go into this in more detail later, but that is a multiplier that allowed OSHA to cite the employer for each violation of individual duty in instances where the standard laid out such an individual duty. But now, and as of late January, OSHA replaced the historical egregious threshold for IBI citations with a much lower bar for OSHA to clear to cite employers on a per instance basis. So now, in addition to willful violations, OSHA can issue IBI citations for violations characterized as serious and even some other than serious violations, so long as the violations are determined by OSHA to be or relate to high gravity violations, which, as Eric mentioned before, it's that descriptor that's based on OSHA's assessment of two things: the severity of the injury or illness, as well as the probability that the injury or illness could occur. Now, these citations still have some limits, as you can see. They're limited and based on the standards that set out individualized duties. And as well as that, in the case of non-willful citations, the IBI citations are limited to high emphasis hazards. High emphasis hazards, as you can see here, it's this list of the hazards which OSHA has qualified as high emphasis, meaning they're the falls from heights, machine guarding, lockout, tagout, respiratory protection, permit required confined space entry, trenching / excavation, injury and illness record keeping citations involving high gravity, serious violations. So by OSHA sort of opening the door to violations of any characterization, meaning from willful down to other than serious, our expectation is that we'll see orders of magnitude more instance by instance citations under this new policy. We also expect that the limit to just specific high emphasis hazards to not last very long might not last. OSHA recently abandoned the high emphasis hazard qualifying limitation in recent changes to SVEP. So it's hard to imagine OSHA keeps that limiting principle in place long after it continues to see presumably massive penalties roll in over the next couple of years.
And I'd add to that, every time I talk to somebody at OSHA about this, we'll talk about, hey, does this apply to this standard? Does it apply in these circumstances? And every time they talk about it, they say, for now. It applies only to this standard for now. So it is very clear that it is at the front of their mind that this is sort of a beta test for their new instance by instance authority, and that they are likely to either abandon a limitation to certain hazards completely, or to add to this list as it goes along. But that's exactly right.
So that, now as mentioned before, like the next part that's really important to understand is the standard setting out this individualized duty. So IBI citations can only flow from standards that clearly require prohibit individual acts. So a good example here is this respiratory protection programs regulation. 1910.134A2 indicates an individualized duty, meaning that employers must provide a respirator to each employee, meaning that a violation comes from each failure to do so. And as a result of this, now each specific violation from failing to provide an employee with a respirator could now be cited with an individual penalty. And then lastly, I think one of the main things to outline here is sort of the factors that OSHA is going to look at when it decides to issue IBI citations. These proposed citations are typically going to be related to a fatality or catastrophe, the employer's sort of 5-year history, whether the employer has received a willful repeat or failure to abate violations in the past 5 years, whether there's been a failure to report, the employer failed to report fatality, inpatient hospitalization, or amputation, or in the case of record-keeping violations, whether the non-recorded or improperly recorded injury or illness resulted from a high-gravity serious violation. So these are sort of similar to the prior Willful plus / Egregious enforcement standard for instance citations, and similar to the qualifying criteria for SVEP. So even though the outcome of an incident doesn't mean that a violation occurred, even though the outcome of an incident does not mean that a violation occurred, or that the employer's conduct is more egregious, typically more significant injury outcomes have driven more significant enforcement.
One thing to note about these factors 2 and 3 is that they're not necessarily related to the current circumstances, the current inspection, the current citations that OSHA is citing on an instance by instance basis. That is, if you have on your record a willful repeat or failure to abate violation, any of those kinds of violations in the last 5 years, regardless of whether they relate to whatever the new thing is, right? You have, 10 repeat violations for blocked exit routes over the last 5 years, and OSHA comes in and finds, and I'm trying to think of a high emphasis hazard issue here. They find that you're not enforcing a fall protection requirement for your employees, even though you've never been cited for that in the past, not as a willful, and they don't think it's a willful violation this time. You've never done it before. If you have repeats or willfuls in your OSHA history, that's what's going to motivate them to cite on an instance by instance basis, even if it's completely unrelated to those old willful or repeat violations. And the same thing under number 3 here. This is not a situation where if you have failed to report to OSHA some event, they learn about it and come out and do an inspection of that event, that they are likely to cite instance by instance. They are in that current circumstance. The situation here is if they find that you have failed to report anything, and this doesn't have a 5-year look back, if there's a failure to report in your history that they learn about something you should have but didn't report, or you've got an old failure to report violation in your record, in your OSHA citation history, then whatever reason they're inspecting you today, you are more likely to get an instance by instance citation. So it may be not even an incident inspection, or it may be an incident inspection that you did report in this occasion. If you have a failure to report in your history, you are vulnerable to instance by instance. So the idea here is OSHA is trying to add a new consequence for failing to report. And they did make clear, and I questioned them on this at a conference recently, does this include late reports, or is this factor right here only failure to report? And they made it clear that this is failure to report. So this is another interesting element for employers to consider now when they are outside the 8-hour window or outside the 24-hour window to report a hospitalization, a lot of employers were making a judgment there. If I report it late, I'm going to get cited. Maybe I cross my fingers and hope OSHA doesn't hear about it. I would never advise anybody that. If it's reportable, it's reportable. Make the report, even if it's late. Take your lumps. But now there's another weight on the scale to say, is it better to have a late report and to be cited for it than to make no report and hope you get away with it? I think now that it's another factor that makes reporting even late way more valuable, because you don't want to be vulnerable to these instance by instance citations. So some interesting stuff that we picked up from OSHA after they announced it, and some discussions with them. Oh, and then, all right, I'm gonna tackle a couple of questions that I've seen, and then get to the last thing that's on our list for today. Somebody asks about serious citations, alleged or confirmed. Can they do this instance by instance at allegation or only after proven? This is an also as alleged situation. So the idea is that it's not like at the end of a process where they've cited you for repeat and they prove it, and they prove that you committed the serious violation, that they can add a multiplier on at the end. This is going to be as alleged. You're going to see in your citation package from OSHA, instead of one serious respiratory protection violation, it will be 10 respiratory protection violations for not fit testing 10 employees. And the whole purpose of this thing of instance by instance is penalty multiplier, right? Instead of a single violation with a single penalty, a single violation of a single standard with one penalty, it's 5, 10, 20 violations of a single standard with 5, 10, or 20 penalties. And now, instead of it only being willful violations with $150,000 violations, it'll be $10,000, $14,000 violations. So still going to ratchet up the consequences of that. And that's going to happen right at the alleged violation stage. And you can defend that. And we have successfully defended that under the old policy. Darius talked about that circumstance where the standard itself, the regulatory text, needs to say that there is an individualized duty. Use words like each employee, each machine, each entry, whatever it is. That we've seen OSHA try to break things up on a per day basis or on a per employee basis, where the language of the standard doesn't seem to support that. And we've litigated that successfully, including prevailing on summary judgment in having per instance citations struck, leaving only a single citation. And this was a case where, it was, more than $1 million fine, that before we even got to whether there was an actual violation, by summary judgment, we got it struck down to a $100,000 penalty instead of $1 million penalty. So that was changed the dynamic for settlement, and we ended up resolving the case very favorably. The penalty, somebody asked, what's the penalty for failing to report? Generally speaking, it's a violation of 1904.39. Generally, those violations, because that's the record keeping standard, record keeping and reporting. Generally, those are considered other than serious violations, and you could face a penalty up to about $15,000 for your first failure to report a hospitalization, amputation, or death. Repeat violations are very common in reporting circumstances. Those can get up to $145,000, $150,000 per violation. Now, there's actually a minimum penalty for failure to report violations, and I think it's $5,000. It might be $10,000, but it's the idea is that it's going to be an other than serious or repeat or willful violation. Now you've added an additional penalty to that failure to report, and that is that it makes it more likely that you'll get instance by instance citations in the future if you have a failure to report on your record, or OSHA determines that you have failed to report something that should have been reported. Really, really good question here about state plans. And Darius, I don't know if you want to talk to the application of this instance by instance policy in the state plans. I'm happy to do it. But if you wanted to, if that's something you were prepared to talk about, that's fine.
I'm happy to have let you take it.
All right, very good. The answer is that the memo that Darius talked about that laid out this new policy, that memo was directed to basically OSHA's field offices and to the state plans. And it requires the federal offices, the federal field offices, to adopt it, and it encourages the state plans to adopt it. And the reason why they are encouraging them rather than requiring them is because it's just a memo. And when Darius talked about the history of the egregious enforcement policy, he was talking about a directive. Remember that 1996, I think it was, directive? That, as a directive, is a much more formal OSHA policy document that the state plans written into that directive were required to adopt. So all state plans have a program at least as stringent as OSHA's 1996 willful per instance enforcement policy. They've issued this memo right now. OSHA has issued this memo, encouraged the state plans to adopt it. This memo is basically an interim measure. It is an interim measure while they work on the directive. And they have told me that they are working on the directive. So the old 1996 directive is going to be rewritten to align with what Darius described here. And when it is written into that directive and adopted as a formal OSHA directive, then the state plans will be required to adopt it or something more painful than it. So that is what's happening with the state plans on that front. So yeah, great question on that. All right. Let's get back into the very last item on the list here, and that is OSHA's new anti-grouping citation policy. And so, and this goes hand in hand, and in fact, it was part of the, OSHA put out a press release about the new instance by instance enforcement policy, and that press release also linked to this new anti-grouping policy. And so what the IBI policy is about is multiple violations of the same standard, right? Literally not requiring a hard hat, 10 violations of it because 10 employees weren't wearing a hard hat. So same regulatory reference, instead of 10 instances in a single citation, it's 10 separate citations of the same standard. Grouping, and hopefully, you know, if you all have ever received citations, you want them to be grouped, and hopefully you've seen them grouped before. Grouping of citations means violations of different standards, but are similar, where the same conduct resulted in a violation of two different standards, or the same abatement would abate violations of multiple standards. So it might be, you know, for respiratory protection, and we were seeing this, you know, all over the place during COVID-19, and particularly for our healthcare clients, where OSHA would come in and say, you don't have a written respiratory protection program, you didn't do respiratory protection training, you didn't do fit testing, and you didn't do medical evaluations. Now, if they felt like you were a good actor and you were just acting on exigencies of the pandemic, and you never had respirators before, and now all of a sudden you do, and you're rolling it out as quickly as you can, they might come in and say, we're going to cite you citation 1, item 1A for no written program, 1B for no training, 1C for no fit test, and 1D for no medical evaluation. But there's only going to be a single penalty because they're grouped. So it's citation 1, item 1A, B, C, and D with one $14,000 penalty. OSHA has, for years and years and years, executed its enforcement discretion to very often group similar violations in that manner. Well, they issued this memo back in January of this year that basically said, stop doing that, or don't do it as much. We want to discourage the grouping of, and this is not just my jaded defense lawyer's view of this. You know, I call it the anti-grouping. I can't remember if that's the exact term that OSHA uses, but they're using something very similar. It might be discourage grouping or anti-grouping or something like that. And that's what this is. The whole idea of this is group less, cite more, higher penalties. We want more penalties. And basically they're saying, we know you have this discretion, area offices, but don't exercise it as often if not grouping would achieve a greater deterrent effect. And I mean, I think we know OSHA's mindset, right? OSHA's mindset is higher penalties means greater deterrent effect. More citations means greater deterrent effect. So it's hard to understand the circumstance where they will group now if the concept is don't do it if it would achieve a greater deterrent effect. And then similarly, they say if don't group multiple similar citation items if there's evidence that the conditions giving rise to the violations are separate and distinct, where different conduct resulted in the violations. Don't group in that circumstance as well. So the whole idea here is group less, increase penalties, and that's where OSHA is going with that. So the last thing we just talked about here, and this is, really the whole concept is what happens when you start to get egregious violations, when you start to get multiple willful and repeat violations, and OSHA designates you as a severe violator and treats you as a bad actor. One is you're much more likely to face a criminal referral. And OSHA can refer cases for criminal prosecution with a willful violation related to a death. I'm not sure I've seen a case referred for criminal prosecution that was not also a severe violator case. Those things go hand in hand when there's a death involved. So you got to be mindful of that. The other thing, just really, really relevant to the instance by instance policy and the anti-grouping policy, is that OSHA's max penalty authority keeps going up and up and up and up. So now getting a decoupled instead of grouped set of respiratory protection violations, or a serious instance by instance per employee violation, instead of facing a maximum $15,000 fine, you could be facing 15 times however many separate violations or however many individual units of violation under that instance by instance policy. And those penalties are no joke now, right? Because of a couple of years of pretty high inflation, OSHA's penalty authority is up pretty high now. And you can see that there can be big effect from these instance by instance or ungrouped violations. Repeat violations, I won't go into it. I talked about it before. OSHA is purposefully finding and citing them as often as they can every year. The percentage of total violations that are characterized as repeats go up. It's not an accident. It's very deliberate policies that OSHA has rolled out, and they are working. And that's how we're seeing more severe violators and more of those 10x penalties for repeat violations. And here, just the last thing I'll show about this is this is not just me paranoid that things are getting worse for employers. You can see that OSHA is setting records for $100,000 plus penalty enforcement actions. Set a record last year, again in a year where inspections were depressed because of COVID. They still managed to set a record, and they're doing that because they're citing more repeat violations, more severe violator cases, and setting up as a pretty clear indicator that we're going to see a heavy dose of this instance by instance citation policy as we move into 2023. And I think that gets us to the end. It does. So I encourage everybody to join us for the remainder of the webinars in our 2023 webinar series. Even if you can't join the day we're presenting, sign up anyway. You'll get the follow-up email with a link to the recording and our slides and all that good stuff. I also encourage everybody to check out our blogs. The OSHA Defense Report blog is the one I spend the most time on, but great stuff on our Cal OSHA Defense Report, our MSHA Defense Report, and our labor and employment team does a really great job with the Employer Defense Report blog. You can check out the blog at, just the name of the blog, drop the, it's OSHADefenseReport.com, same convention for the others. And our webinars, we have a webinar archive, webinar library on our website at conmaciel.com. And you can find that under events and webinars. The webinar library is on there. And then likewise, we're going to email you today or within the next couple of days with a link to the recording of this one. I have tried to cover all the questions that I saw come in as we move through the program. But if anybody has any other questions, feel free to shoot Darius or me an email, or reply to the email when you see the webinar link come out the next day or two. And as always, it's a pleasure to join you all. I thank so many of you for sticking with us beyond the hour. But this was one I was looking forward to a lot in this year's program, because these two, in my view, and this is not just, paranoid defense lawyer obsessed with severe violator. I think these are real game changers. I think OSHA has for many, many years felt like their enforcement teeth were not sharp enough, that they couldn't enforce the way EPA did and other regulators could. I think these are the kinds of tools that allow them to do that, to make life much more painful for employers. And I think they're going to exercise these tools. They're going to use all the tools in the toolkit. And I think we're in for a really rocky last couple of years of this term of the Biden administration. And then who knows what happens after that. But thanks everybody for joining us today. And we look forward to visiting with you again next month. And we'd love to be a resource for you. So don't hesitate to reach out. Thanks, everybody.